The next case is State v. Anderson. Each will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
Your Honor, with the court's permission, I'd like to reserve 5 minutes.
Certainly. I will make note of that. You see it up there on your left at that clock. You'll look at the top one. Please ignore the bottom one throughout the argument if you would.
Yes, sir.
And I'll try to let you know there's about a minute left in case you're not looking over there at your initial time. And counsel, I'll try to let you know about a minute of your time of rebuttal. You are the minute clock to be looking at. The arguments are being recorded. When you present your argument, make sure you come before the podium. Stand behind the podium, speak loud enough so we can hear you. If during your argument you need to refer to the name of a child, a minor, or a victim, please refer to them by initials, or some term like a minor or victim if you would. Having said that, we've read your briefs and are ready to proceed whenever you are, Counsel.
Thank you, Your Honor. Please, the court, Attorney Anna Van Ho on behalf of Mr. Jarrell. Your Honor, the major issue that I have with this case is the fact that the enhancement on this case is based solely on...
And Mr. Van Ho, I know you're doing the next two, so this first one is Mr. Anderson.
I apologize, Your Honor. I misread the thing outside.
That's what I have, and I misread. Is that correct?
I'll do however. I know I'm being tag teamed by the prosecutor's office today, so as well as their intern, the staff apparently. So
I'm here for Mr. Anderson.
So I'm a little bit confused. So I apologize. No,
that's okay. I'm glad we stopped that.
I appreciate it. Otherwise, I was going to have a really cool argument for the next case. Your Honor, please support. My issue with Mr. Anderson's case is the enhancement to create this turn into a felony 3 based solely on a charge for which Mr. Anderson was not convicted and was actually found was acquitted. This was not a case where there was a general catch-all that any felony that he committed a violation of protection order during the course of any felony. This was that he committed it during the course of a menacing by stalking. And I look specifically at the jury records, or the jury instructions, which I referenced in my brief. And in order to find the person guilty of the enhancement, you have to find beyond reasonable doubt that he also committed the act of menacing by stalking, which the jury did not do. I understand that there are inconsistent verdicts in and of themselves do not rise to the level of being against the weight of the evidence. However, in the case here, the verdict results themselves were completely inconsistent, and that's why I actually cited to Raines, which I know does predate some of the case law that the prosecutor has cited and the state has cited. However, I think Raines is actually an excellent example where you cannot have a racketeering conviction unless you have the predicate convictions as well. In that case, I think it was the trafficking in cocaine, where you did not have the racketeering based on, as a predicate on trafficking in cocaine, which Mr. Raines was found not guilty of. Similarly, in this case, where we have this as an issue where, based on the testimony itself, my understanding is there may eventually be some post-conviction, post-motion for new trial being filed and some new evidence, but based on the evidence that the jury received, when they then come back with that verdict that says he did not commit menacing by stalking, it is completely legally inconceivable for them to then say, we are convicting you and enhancing your sentence based solely on the based solely on menacing by stalking. The other close comparison I would have to that would be if you had a domestic violence where the person is convicted in the fourth degree of domestic violence based on predicate conviction for domestic violence, but the jury finds that he did not have, the state did not satisfy the requirements for that predicate.
Counsel, I want to ask you a question in regard to this because it seems like you're making a legal argument, okay, that, in other words, in your actual assignment of error, you say sufficiency and weight, but really isn't sufficiency and weight, or is it just a legal argument? Because if he's not convicted of the underlying offense, you're saying this is a predicate offense, so therefore he couldn't be convicted of the felony.
I'm saying that it's both a legal and it's a factual argument.
I can't hear you.
I'm sorry, ma'am. The weather is making my vocal cords drop.
My allergies are horrible. Yes.
It's a combination of both a factual and a legal argument. Because in order for him to be convicted, in order for there to be sufficient evidence, you have to show that that one of the elements of that has to be that he was convicted of domestic by stalking. So it's a combination of a legal and a factual argument. It's not one or other. This is one of those few cases where I think we can say, look, the law is against the state on the argument of was he committing a felony during the course of a violation of protection order. And I return to, because it specifically stated this is the felony he violated, which is the menacing by stalking, and the jury then returns its verdict. The verdict actually becomes the inconsistency of what creates a combination of manifest weight and as well as a insufficiency of the evidence. The evidence was not sufficient for the jury to convict him of menacing by stalking, so how could you then find the enhancement applies? And I see Judge Sutton is giving me a side eye right now.
No, not
Okay.
at all.
So that's the basis of my argument. So unless the court has any questions, I will reserve the rest of my time.
Thank you, Mr. Van
Thank you.
We're there 5 minutes for
Thank you.
Good morning. May it please the court, my name is Rick Raley on behalf today of Summit County Prosecutor Elliot Kolkovich and the appellee of the state of Ohio in this case. I look at this as a legal argument myself, and I think that it's already been decided by the Ohio Supreme Court that the defendant's claim in this case is foreclosed. Inconsistent verdicts are immaterial as a matter of law. We allow juries to make inconsistent verdicts because they consider counts separately and independently. We do not engage in their deliberations. They are secretive within their jury room. They may make these decisions based on, mistake, compromise, or lenity. Perhaps they looked at this case and saw we should only find one conviction in this, so we're only doing it one conviction. The other one we're going to say is not guilty. That's perfectly appropriate for the jury system, and I think that this court has to reject the defendant's assignment of error. And I would just re-emphasize that the reliance on Reyes is misplaced entirely. It does predate that Gardner case from the Ohio Supreme Court, and other courts who have looked at Reyes says it is no longer good law. So unless there are any questions, I ask that you affirm.
Thank you.
Thank you.
Separately, we all understand juries do things for different reasons, okay? But the fact of the matter is that the jury, we expect them to follow the instructions of law as they're given. And one of the instructions of law is you must find beyond a reasonable doubt every element that for the underlying offense, the menacing by stalking, for them to then first say, we're finding you not guilty of menacing by stalking, and then turn around and say, but we find you're guilty of this element of it. That's where the inconsistency creates a problem, and that's where it creates a situation where you do have an issue of the appellant being deprived of his right to have a verdict that at least makes sense. This verdict does not make sense, because on one hand, and I understand the idea that the juries can make up their minds for their own determination, but if we're going to presume that the jury follows the law in this case was if he's not guilty of menacing by stalking, we do not check that box on the jury form, and he is at that point convicted of a first-degree misdemeanor violation of protection order, which is what the evidence actually supports. So unless the jury of the court has any other questions, thank you.
Thank you, Mr. Van The court will take the matter under advisement and issue a decision in due course. When that decision is reached, will be mailed to you by the clerk of courts and also be available on the Ohio Supreme Court website. With that, I'd like to thank both of you for your presentation and behalf of the court.
Thank you.